Hello everyone, good morning. Today is 6th of August and welcome to the Hindu newspaper analysis discussion. So friends, in the today's video, we will be discussing the entire Hindu newspaper with the background as well as the way forward in the relevant articles. Guys, meanwhile, I would like to tell you that you can download the explainer PDF from the Telegram channel. Fine, and the link for the Telegram channel has been given in the description box. Moreover, you can search for the Telegram channel also in the search bar in Telegram. Okay, now guys, before moving on, first of all, let's take the overview of the entire newspaper in order to understand that which articles are actually relevant for our examination, and overview also makes you to learn this particular art. Fine, as how to identify the relevant articles. Now this is the page number 1 and I here have the Delhi edition of the Hindu newspaper. So the first article, RBI raises rates, was nimble policy. So guys, here we have seen that the RBI, it has increased its repo rate by 50 basis points and now the repo rate stands at 5.4%. Now guys, that why this repo rate has been increased? So basically now the RBI is going for the tight monetary policy, and when the tight monetary policy is taken, when the inflation is high, and recently we have seen that inflation is hovering above the comfortable range. Okay, so this is something. Now guys, you don't need to go too much in detail in this particular article, and you don't need to see that okay, how much exactly is the repo rate and all these things for your UPSC examination. Fine, just you need to have a kind of an understanding about this thing. No need to go too much in deep. China sanctions, Pelosi suspends key US stocks. So guys, we have seen recently that the US's US's House Speaker Nancy Pelosi visited to the Taiwan, and after that the China has showing the confrontation against the Taiwan and has said that there will be the targeted military attacks around the Taiwan. Okay, now in this particular direction there is one editorial also, will take that particular article. Then guys, Supreme Court seeks government's reply on the seizure of devices. Now what this article is talking about, see, basically many a times the enforcement agencies such as the CBI and many such agencies, they basically they arrest the people. Sometimes academicians are there, and when they are arrested, even their mobile phones, their laptops are confiscated. Now the academicians, they are saying that there is a lot of academic work into these laptops and they should not be seized. So in that particular direction, Supreme Court has asked the reply of the Ministry of Home Affairs. However, the government had said that they are the crucial part of evidence. Fine, so just that's it, that is there. Then India witnessing a death of democracy. So basically because of the rising unemployment and all these things, such a things are coming. Fine, now this article is important for our UPSC examination and we'll see this article in much detail. Supreme Court moots verdict for bodily autonomy. So with respect to the MTP, women's reproductive rights, this article is going to be important and we'll see this entire issue. Then moving on the city section, CM to distribute 25 lakh flags. Fine, and basically the advertisements, tenders and all these things have been given in the regional section, not important for your UPSC examination. So we will simply be skipping and will reach to the editorial section. So in between, relevant articles are not there. Now the first article, it talks about the lessons for India from the Taiwan standoff. So China, Taiwan, US triangle, we'll see in this particular article. Then below article addressing the challenges in the new age digital commerce. So it is a good article talking about the online dispute redressal. We'll see this article also. Then fresh opportunity. So guys, this article talks about the withdrawal of the personal data protection bill 2019. We'll see this article. Then moving on, sticking to commitments. Fine. So guys, this article, it is talking about that India has revised the NDCs. India has revised the NDCs, that is the nationally determined contributions. Fine. So we have seen that basically earlier, that is in the COP26, we have taken the Panchamrit 5 targets. But out of these 5 targets, we have adopted 2 as an official upgradation in our INDCs. Fine, already I have also covered this particular article in much detail from 2015 to 2021, how this particular thing has developed. I have already covered this particular thing in the previous day's newspaper. Okay. Then guys, moving on, so today is a Saturday. On Saturday we have this ground zero report. Now what this ground zero report is talking about, it is talking about that how one Mr. Kamal Lodha, who was a laborer, he was sentenced to the death and then it was found that he was not actually guilty, and that personal story is being discussed. For UPSC examination, this article is not important. Then guys, today as it's Saturday, so we don't have the text and the context page, so that is not there. So we will be coming to the page number 8. Privilege of MPs does not extend to criminal cases. We'll see this particular article with respect to the GS paper number 2. After that, basically the political news etc are going on, not very much important. Mandatory voting is not practical. So guys, with respect to again polity, we'll see this particular article. Then after that, the political articles etc are not important. Swaraj is not limited to just self rule. Fine. So basically here the Minister of Home Affairs had said that the Swaraj is not the self rule, rather it is an affirmation of your religion, culture, arts, dharma and all these things. Fine. Then moving on, after that, basically self rule is most relevant solution. Valley sees partial shutdown. So guys, these articles are coming because yesterday was 5th of August and the 5th of August was the 3rd year anniversary since the article number 370 got diluted and the Jammu and Kashmir's special status was withdrawn. Fine. So on that particular thing, these issues are coming. With respect to the examination, UPSC, nothing is relevant in this particular article. Then advertisements etc are going on. After that guys, moving on. So in this particular direction, here we can see that the center has launched the portal to register the register for rations. We'll see this particular article. Then prepare infrastructure for developing the monkeypox vaccine. Fine. The task force has provided this thing. Hooch claims 11 lives in Bihar and all these things. Fine, not important for your examination. Fine. Supreme Court asks center to follow upon its lynching rulings. Okay. So basically in the past we have seen that many of the targeted attacks had happened on some of the religious communities. So these lynchings and all these things have to be addressed. Then moving on, US won't let China isolate the Taiwan policy. So this is again the China Taiwan US issue is going on. I'll cover it with the editorial article. Then Israel strikes on the Gaza, kills at least 10. Fine. So basically guys, this is an article with respect to the Israel-Palestine issue that is going on. Fine. So however, you don't need to see that okay where the military strike happened, how many people got killed and all these things. Policy dimensions are important for our examination. Okay. Then Kashmir issue should be resolved peacefully. Okay. So China urges India, Pakistan that basically peacefully this particular matter should be resolved. Fine. However, moving on the business page, banks cannot always rely on RBI to fund credit takeoff. Thus, okay. So basically here it has been provided that this basically banks should not always be dependent on to the RBI, that RBI will be doing an intervention in basically these credit offtake scenarios. Fine. Rate hike may hit home sales. So recently we have just today we have seen on the first page that the repo rate has been increased. Interest rate hikes will be there, and if interest rate hikes will be there, obviously the home loan etc are going to be increased. Then M&M Q1 profit, okay, and all those things have been discussed. Okay. Then we have the sports page. So guys, this is all about the overview of the today's newspaper, and let's discuss the relevant articles which are important for UPSC examination one by one in the detail. Now guys, in every class I start the class with the GS quotation, and I don't take these motivation etc type of quotations. I take the quotations which you can use in your GS paper or in your essay. So today we are going to take the quotations from the John Stuart Mill, JS Mill. So what JS Mill says? JS Mill says that a person may cause evil to others not only by his actions but by his inaction, and in either case he is justly accountable to them for the injury. Now guys, understand, basically there was a French philosopher Montesquieu had said this particular thing, that in a democracy, basically apathetic citizenry is also a point of concern. Even the people who are not raising the voices, the people who are silent, it is also a point of concern. And the similar thing has been provided by the JS Mill. JS Mill said that okay, you not only your harmful action, your violent actions are wrong, but even if the wise citizens, if the good citizens are silent on the major issues, that is also hurting the other people. Why? Because the justice for their cause is not being sought when the good citizens are silent. So inaction also leads to a kind of an indirect violence, indirect injustice. So the active citizenry need to take active participation into the democratic deliberations and democratic processes. So that's all about this particular that is all about this particular GS quotation. Please use this particular idea in GS paper number 2, GS paper number 4, as well as in the essay. Fine. That is all about it. And now let's take the first article. So guys, the first article we have taken from the Hindu, page number 1. So first of all, let's read the heading of this particular article. What it says: Supreme Court moots verdict for the bodily autonomy, the bodily autonomy. Now guys, basically if you just directly read this particular article, it is not going to make a lot of sense. So therefore, first of all, we need to know the background of this particular article, and therefore the background becomes more important. After that, the article is just a one liner concept. Now guys, I will tell you the background. So basically, the story of this particular issue starts from 1971. Now guys, before the 1971, basically inducing a woman to go for the miscarriage was a criminal offense. Okay, so basically abortion was not allowed before the 1971. Meanwhile, the government constituted one particular committee. The committee's name was the Shanti Lal Committee. The Shanti Lal Committee provided this particular thing, that we don't have any law which allows the women to go for the abortion. Rather, if a woman is going for the abortion, or if somebody is helping a woman to abort a child, that is a criminal offense. That is not the right thing. We need to recognize the rights of the women to abort. And therefore, in 1971, what happened? We came out with the MTP, Medical Termination of Pregnancy Act 1971. Now, this Medical Termination of Pregnancy Act 1971 allowed the abortion. It provided that the abortion till the 12 weeks, abortions till the 12 weeks are allowed if one registered medical practitioner advises. If one registered medical practitioner advises, abortion till 12 weeks are allowed, and between 12 to 20 weeks. Okay guys, please listen these particular timelines very clearly. So from 12 to 20 weeks, the abortion was allowed if two registered medical practitioners will advise that particular thing. So till 20 weeks the abortion was allowed. Now guys, in what conditions the abortion were allowed? There were certain conditions. Now let's understand these particular conditions. So basically the conditions were this. Number one, if there is a risk to the life of the pregnant women, abortion is allowed. If the pregnancy will cause the injury to the physical health or the mental health of the mother, the abortion was allowed. Then there was a substantial risk that the child that will be born, it will have some physical or mental abnormalities, or a child will be handicapped. Fine. In these particular circumstances, the abortion was allowed, but the limit was till 20 weeks. So this particular thing was provided into the 1971 MTP Act. Then guys, what happened? Basically, we went for some change in this particular law. We said that actually more women's abortion rights are to be recognized, and then finally what happened? We came with the MTP Act 2021. MTP Act 2021. Now let's compare the MTP Act 2021 with the 1971 law. What got changed? So basically guys, when we talk about the MTP Act 1971 and 2021, here is a comparison. 1971 Act was only applied to married women. It covered unmarried women also. How it covered unmarried women? Because the word husband was replaced with the word partner. So unmarried women were also covered. Now earlier, till 20 weeks, the abortion was allowed. Here the abortion has increased to 24 weeks. Now I will come on this 24 week point in just a minute, because here a controversy comes. Then we have seen that earlier till 12 week the pregnancy abortion can be carried if one registered medical practitioner allows. From 12 to 20 weeks the abortion was allowed if two registered medical practitioners allowed. Now into the 2021 Amendment Act, what has happened? The limit has been increased to 24 weeks. So till 20 weeks, one registered medical practitioner's opinion is to be taken, and from 20 to 24 week, two registered medical practitioners' decision is to be taken. However, the abortion is also allowed after 24 weeks, but for that a medical board's approval has to be taken. Fine. So this is something that happened. Now guys, understand this particular thing. Now an important part comes. Please be very attentive here. So MTP 2021, and in between there are the MTP rules also that came in place. So basically guys, it was provided that, see, if the abortion is to be carried till 20 weeks, then the abortion can be carried if one registered medical practitioner advises, and the ground of abortion could be that there will be the mental trauma if a pregnancy will be carried, abnormalities there, okay, some risk to life of a mother, and all these grounds were there. Now if the abortion is to be carried till between this 20 to 24 weeks, there are the 7 grounds that have been given. Now these 7 grounds are little bit there which are discriminating against the married and the unmarried women. So basically till 20 weeks there was no problem, but 20 to 24 weeks there are specific 7 grounds in which the pregnancy can be aborted. Now let's see, first of all, what are these 7 grounds? Number 1, if the pregnancy is a result of a assault, rape, incest. Second ground, if the girl is a minor, that is less than 18 years of age. Third, if there is a change of marital status. Now what is a change of marital status? During the pregnancy, if the women became widow or if the women got divorced. Then there was a fourth ground, that if the women with physical disabilities have got pregnant, okay, mentally ill women who are mentally retarded, they can go for abortion. Then if there is a fetal malformation, okay, and it is provided that if the child is born, the child will have the physical or mental abnormalities or the child will be handicapped, then the abortion can be carried. Or if the women with pregnancy is struck in some humanitarian or some disaster or some emergency like situation which will be declared by the government. So these are the 7 conditions only under which the abortion can be carried between the 20 to 24 weeks. Now guys, the issue comes, see, is that basically recently what happened, one of a girl actually approached the High Court and then approached the Supreme Court. She said that actually she is not married, she got pregnant, now she want to abort the child because her partner, he has refused to marry the women, so she want to abort the child. Now the pregnancy was more than 23 weeks. The court refused to allow her the pregnancy. Why court refused to allow the pregnancy? Because they said that you are not coming under the definition of these 7 grounds, and only in these 7 grounds the pregnancy is to be aborted. Now here basically it has been said that there is one ground, the change of marital status, but you have not altogether been married. Moreover, the pregnancy is not because of an rape, you are not a minor, there is no physical deformity, and marital status has been discovered, had written here, you are not altogether married, so you cannot be allowed to abort the child. This particular thing was actually coming in between. High Court said earlier this thing that you will not be allowed, then Supreme Court actually allowed her that okay, you can go forward. Now the question comes is that actually when this category of 20 to 24 weeks is concerned, it discriminates between the married women and between the unmarried women. Unmarried women, if they are over 20 weeks pregnant, they don't have any ground under this particular conditions. Is it clear? They don't have any right. So therefore the Supreme Court says that the bodily autonomy, the bodily integrity, the reproductive rights of the unmarried women are getting violated. So therefore the Supreme Court says that in this, now guys, what the Supreme Court says that the rules under the MTP Act that permit pregnancy up to 24 weeks into the 7 categories, these rules are either to be amended, or into these rules the unmarried women are to be given a kind of a they are also to be given a kind of a right to access the abortion. Guys, when these abortions are not available, what women are doing? Women are approaching the unsafe abortion facilities, which sometimes are most of the times unhygienic, they are unsafe, they are deadly for both the mother as well as the fetus. So this is something that has been there. So guys, if you know this entire background, then just reading the headline even of this particular article will help you know that what is provided in this particular article. So the Supreme Court is exploring that we need to expand the scope of the MTP. Fine. So this is the entire issue. Guys, please download this PDF from the Telegram channel, and please put this PDF in your GS paper number 2, where this particular article is going to be important. This article is going to be important in GS paper number 2, social justice, women related issues. Fine, very important one. Now moving on. Moreover guys, this particular year, see, again I'm telling you, this particular year and the next year, the abortion is going to be a very important topic. Why? Because the Roe versus Wade judgment has come in the Supreme Court, which has rolled back the abortion rights that were given to now the Roe versus Wade judgment has been overruled. It has been rolled back. Actually, the Roe versus Wade judgment came in 1973, and in this Roe versus Wade judgment, what happened? The Supreme Court of the USA provided that the women in the USA, they have the right to go for abortion. But now this particular thing has been rolled back. Now it has been said that no right to abortion is there. If the state wants, the state can decide on the matter of abortion. So this Roe versus Wade judgment has been rolled back. So therefore it is an important issue for GS paper number 4 also this year and next year. Now moving to the next article. privilege of MPs does not extend to criminal cases, says Venkaiah. So basically, Rajya Sabha Chairman Mr. M. Venkaiah has provided a very important interpretation with respect to the immunities of the members of parliament, and therefore this particular article, it's going to be directly important for GS paper number 2. It's directly be going to be important for GS paper number 2, issues related to polity. Okay, now let's understand that what this particular article is all about. Now guys, you might have already read in your polity, fine, that when we talk about the members of parliament, MPs, they have been given a privilege. What is the privilege? Privilege is mentioned in article number 105 of the Indian Constitution. Now the MPs privileges, it provides that while they are performing their parliamentary duties, they should be provided that they are not being restricted. In this capacity, it has been provided that an MP cannot be arrested in a civil case. An MP cannot be arrested in a civil case 40 days before the commencement of a session or a committee meeting, and 40 days after the commencement of a session or committee meeting. So 40 days before the parliament convenes and 40 days after that, an MP cannot be arrested. This is an individual MP's privilege provided to an MP. Clear? Where article 105 is there. So this is one thing. Now guys, coming to the present circumstances, what is happening? Many of the MPs are being charged by the enforcement directorate. There is enforcement directorate, there is the CBI, fine. They are arresting many of the MPs, they are charging many of the MPs, and these MPs have said that arresting them, it is a violation of the article number 105 of the Indian Constitution, because they enjoy the privilege. They enjoyed the privilege. Now in this particular direction, the chairman of the Rajya Sabha, he has cleared that these privileges that you are talking about, these privileges are available only in the civil cases, only in the civil cases. Now the MPs, the ones which have been arrested, they have been arrested, particularly some of them, under the Prevention of the Money Laundering Act. And the Prevention of a Money Laundering Act, it is a criminal act, it is a criminal offense. So if the MPs are getting arrested for the criminal offenses, they cannot claim the immunity provided under article number 105, because it provides only immunity into the civil cases, but it is a criminal cases. Moreover, there was the ruling given in 1996 by the Dr. Zakir Hussain. So Dr. Zakir Hussain was the president at that point of a time. It was provided that the members of parliament do not enjoy certain privileges so that they can perform their duty, MPs, they do enjoy certain privileges so that they can perform their duties. One such privilege is freedom for arrest when parliament is in session. Now here it has been further clarified that this particular privilege, it is not unlimited privilege. This the freedom from arrest is limited only to the civil cases and has been allowed to, and basically if there is a criminal proceedings, then they could get arrested. They don't have any such immunity, any such privilege in this particular case. Further, the chairman has provided this particular thing, that if such a kind of a thing is there, and if investigating agency arrests them or want to investigate them, then they should cooperate. Here it has been provided that as a lawmaker, fine, I'll highlight, as a lawmaker, it is our bounden duty to respect the law and the legal procedure. So guys, here it is calling about that there is a need of parliamentary ethics, there is a need for parliamentary ethics, there is a need of political ethics, that whenever such criminal charges are being levied, so they should submit themselves to the scrutiny. But at the same time, there is also one more thing, that selectively certain legislators should not be targeted by using these laws and these investigative agencies. If there is an application of law, that also needs to be uniformly applicable on all the legislator, irrespective of the fact that whether he belongs to the ruling government or he belongs to the opposition government. So two things need to be there. Number one, first of all, we need to make sure that there is no selective application of law, and secondly, on whosoever such kind of a law or such kind of charges are being framed, they have to submit themselves for the scrutiny, because they are not the private individuals, they are the public individuals, and in capacity of constitution they are holding an office. That is all about this particular article, guys. I hope that you understood it. I'll read what the Rajya Sabha chairman had said. He said that no member should avoid appearing before an investigating agency whenever he or she is called upon by citing the reason of the house duty. As lawmakers, it is our duty to respect the law and the legal procedures. That is all about it. And now let's move to the next article. Mandatory voting is not practical, says center. Okay, so this particular article, guys, will also be important with respect to the GS paper number 2. GS paper number 2, rights versus duties, or fundamental rights versus fundamental duties. For now, let's discuss this particular article, and guys, I will tell you first of all from the scratch, find the background. So basically what has happened, there was a private members bill that was brought into the parliament. Now first of all, what are the private members bill? Private members bill are any bill which are being raised by the MP, which might be from the ruling government or opposition government, but who is not a minister. So any MP who is not a minister, if he is bringing a bill in the parliament, that bill will be called as a private members bill. So recently the private members bill was introduced, and what was the name of the bill? The name of the bill was the compulsory voting bill 2019. Now what this particular bill provided, this bill simply, guys, provided that we need to legally enforce a duty onto the citizen that they have to cast the vote, and if any citizen is not able to cast a vote, then those citizens are needed to be punished. This particular bill provided that the Election Commission of India needs to make an authentic list, and in this particular list it needs to provide the names of the people who have skipped the voting or who have not voted, and on those people 500 rupees of fine needs to be imposed. So this is something that was provided, and it was said that it is actually a fundamental duty, it was provided that it is a civic duty that you should vote, and if somebody is not voting, then they should be imposed a fine of 500 rupees. But guys, now this particular bill has been put to rest. This particular bill has been has been said that it is actually not going in line with the democratic principles. Why? So basically there are certain issues which will come in this particular direction. Number one issue that will come, that it is actually an impractical idea. There will be a lot of legal challenges if you will make it as a compulsory duty. For example, number one, suppose there is a daily laborer, suppose his vote is in Bihar, he is living in Delhi, and he is a rickshaw puller. So for him it is not possible that he can go back to the Bihar and can vote. Fine. So therefore such kind of a poor people, they will be charged, and for them 500 rupees fine will be huge. It will be a kind of a lot of liability on those people. So therefore it is wrong. Secondly, guys, it has been said that many people who have the muscle power, they will misuse this particular bill. Now suppose, let's say you are a very powerful political person and you had ordered this particular thing to everyone that everybody should vote for me. Fine. Now you can actually look at this particular list that will prepared by the ECI who had not voted, and you can torture then that person, you can intimidate that particular person. So it has been said that many candidates who have muscle power, fine, and who have actually been promised by the voter that they will actually be voting for them, then they will use this particular list to settle the score. Moreover, see this particular thing, that when we talk about the democracy is about government for the people, by the people, and of the people, and how you can punish the people for not voting. So it is not a very democratic kind of thing. So therefore, guys, such kind of a bill is not needed, and such kind of a bill might go against the democratic principles. So therefore this is the issue that has come here. Fine. So the mandatory voting is not practical, has provided by the center, and this private members bill will now probably not be taken forward. So that's all about this issue. Now moving to the next article. Okay, so this article, guys, we have taken from the Hindu newspaper, The Fresh Opportunity, and here I have provided you a very beautiful pictographic which is providing the entire issue in a nutshell, that what was the issue. Now first of all, this particular bill is going to be important for GS paper number 2. GS paper number 2, right to privacy. GS paper number 2, right to privacy, rights, issue, fundamental rights, polity, all these places this article is important. Now before going in this particular bill, guys, this article, I will give you some of a background first so that you can understand this entire issue. Background. Now the background goes like this, guys, that actually what happened in 2017. The story starts from 2017. The Supreme Court came out with an important judgment. The judgment's name was Puttaswamy judgment, Puttaswamy case. Now What was this Puttaswamy judgment? In Puttaswamy judgment, the Supreme Court recognized that right to privacy is a fundamental right contained under Article number 21 of the Indian Constitution. Article 21 is about the right to life and personal liberty. So within the right to life and personal liberty of Article 21, right to privacy is contained. It was ruled. Now guys, as right to privacy got recognized, there was a need that actually the privacy in a digital sphere is also important, and it was provided that we need to provide the rights or to the people over their data, including the digital data that they are generating. And in this particular direction, what happened, actually government constituted one committee. The name of the committee was B.N. Shri Krishna Committee. B.N. Shri Krishna Committee. So this B.N. Shri Krishna Committee was given a task that you need to suggest us the privacy framework. You need to suggest the privacy framework. Fine. Now this B.N. Shri Krishna Committee provided that actually government needs to come out with the personal data protection bill, and even the B.N. Shri Krishna Committee submitted a draft personal data protection bill also. It gave this particular draft to the government and said that on the basis of this draft personal data protection bill, you come out with your own version of the personal data protection bill. Clear? So guys, I hope that the chronology is clear. What happened? Puttaswamy judgment. After Puttaswamy judgment, B.N. Shri Krishna committee suggested the personal data protection bill, and this particular bill, on that particular bill's basis, then government actually came out with the personal data protection bill of 2019, PDP, personal data protection bill of 2019. Finally government came out with that. Now guys, this particular bill, what has happened, this bill which was floated by the government, it has now been rolled back. Government said that there were a lot of criticisms that came in between. Government says that meanwhile there was a lot of criticism and there were a lot of amendments etc. that were provided. We will bring a new bill altogether. Fine. So this old bill has been taken back. Now guys, first of all, let's understand that what were the major issues in this particular bill. So basically, the first major issue of this particular bill was that an overemphasis on the national security angle was given. So basically, I'll tell you that when this particular bill came, this bill recognized the rights of the data principal over their data. Who is a data principal? Data principal is any person to whom the data belongs. Suppose you uploaded a photo on the Facebook, you are a data principal and that photo belongs to you. You have a right over that particular photo where it can be used. And this particular bill also mentioned the right to be forgotten. Right to be forgotten means that you can ask a data fiduciary. Who is a data fiduciary? Data fiduciary is any organization, any person, any company who had stored your data. So a data principal, that is me, whose data it is, data principal can ask a data fiduciary that they need to delete their data and all such kind of things. Even the right to be forgotten has been recognized recently also by the Supreme Court. So all these things were provided in this particular personal data protection bill of 2019. But guys, in this particular bill, the national security angle was given a lot of importance. It was provided that sometimes the right to privacy can be violated if the national security angle comes in between. Basically guys, it was provided that the B.N. Shri Krishna Committee provided that okay, security of state is important, on whose basis the data principal's right might not be recognized, but actually center added one vague ground. What was the ground? They added the ground of public order. So they said that if any particular thing will impact the public order, then the right of the data principals might be compromised. Now public order is a very vague category. Just by citing the public order, virtually all the rights of the data principals can be taken up. If you could have added the security of the state, it could have been little bit, though even here a lot of different interpretations could be there, but still it was very much objective in compared to the public order category. So for this particular thing, this bill was criticized a lot. Secondly guys, then when this particular bill was suggested by the B.N. Shri Krishna Committee, B.N. Shri Krishna Committee suggested that we need to constitute one agency by the name of the Data Protection Authority. Data Protection Authority will protect the interest of the data principals, fine, and all those particular things. But guys, actually it provided this particular data protection authority, and moreover this B.N. Shri Krishna Committee also recommended that this data protection authority will be having a judicial oversight in the selection process. So when the DPA members are being selected, the judiciary will keep an oversight. fine. But actually when government came out with their 2019 bill, it provided that the composition will be decided completely by the executive, no judicial oversight was there, and the union government was giving a lot of power in choosing the members of this DPA. So therefore there was a major criticism. The biggest criticism was with respect to the DPA. The DPA was completely, data protection agency will be completely chosen by the union executive. Second was that there was a vague grounds in which the information will not be shared. Fine. Meanwhile guys, as this particular bill was going on, the bill was referred to the joint parliamentary committee also. Now this joint parliamentary committee was given the 6 deadline extensions. Okay, sometimes their member got changed, sometimes whatever they recommended it was not acceptable. Fine. And up till now this particular bill, it has been come nearly 3 years, it is hanging in between. Nothing happened on this particular bill, and now this particular bill has been rolled back, and government said that they will be coming with a fresh bill, and that fresh bill will address many of the challenges that are there. Now guys, one particular thing I am telling you very clearly. See, now you are not required to go and see the provisions of this particular bill, and deliberately I am not also telling you the step-by-step provisions of this particular bill. Why? Because now it is logically not needed. It has been removed, it has been scrapped. So even if now you need to read a new bill that will come. So old bill, its provisions is not important, but these major 2 criticisms that were there that I told you, this is something that you need to know. Beyond that, no need to go. That's all about this article, and now move to the next article. Addressing the challenges in the new age digital commerce. Now this is an important article guys, okay, and this particular article will see with respect to the GS paper number 2, alternative dispute resolution processes, as well as GS paper number 3, e-commerce industries and its challenges, issues associated with that. Now guys, this particular bill, it is talking about a good idea, that is the online dispute resolution. Now basically when we see presently in India, the e-commerce industry has boomed a lot. Fine, a lot of users are using the e-commerce websites, applications such as the Amazon, Flipkart to get a lot of merchandise items. Today the India's consumer behavior has radically changed. Earlier we were visiting the brick and mortar stores, but today we are not going over there, we are buying the goods and our needs from the online shops. Now guys, first of all, when we talk about the pandemic had further expanded this particular behavior of the consumers. Their dependence on these online sites, etc. have increased a lot. Now guys, but at the same time there are certain criticisms also. The criticism is that the small enterprises such as the local kirana stores, they have not gained from this online inclusion. Fine, because they have seen that their customer bases have been reduced, because now everybody is ordering things from the online. Clear? You are ordering online the personal care items, online education is being taken, medical consultation is being taken online. Fine, doorstep delivery of grocery and all those things are there online. Fine. So actually in a way, first of all, there is a digital vacuum that has been created, as the local kirana stores have not been able to take an advantage. Now guys, meanwhile government came out with one more initiative in this particular direction, that is the open network for digital commerce. Now I will just tell you this particular initiative in little bit more detail, in more simple words, and then I will come back to this particular article. So basically guys, what is this ONDC? ONDC is the open network for digital commerce. So right now what happened? Right now, let's say you go to Amazon. Okay, this is, let's say, the Amazon's application, and you want to buy the shoes. So you will type the, for example, Nike shoes on Amazon. Now all the sellers who are listed onto the Amazon site, their name will come. Their name will come. Okay, and you will buy in from one of them. Your work is done. Now one particular problem comes is that we have 2 of the big online sites today. One is the Amazon and other is Flipkart. Now both the Amazon and the Flipkart, first of all, Amazon, it is a US enterprise, and the Flipkart, in the Flipkart the majority of the stake has been bought by the Walmart. Again, the Walmart is of USA. So today the biggest e-commerce sites, they have the presence of the USA in them. So therefore it is a problematic thing. Today guys, there are many of the other startups, other websites, e-commerce websites also who are trying to come, but actually they are not able to scale. Why? Because the Amazon and Flipkart, they have actually taken all the traffic. Fine. So the even let's say suppose I'm a small seller, I get enrolled on some XYZ small e-commerce site. Obviously the traffic is not there. Ultimately I have to move either to the Amazon or Flipkart, or I have to stop my operations. So only an Amazon and Flipkart is there, a kind of a duopoly has been created. So therefore this ONDC framework has been suggested. Now what is this ONDC framework? According to it, we will create a platform where, let's say, you are going on Amazon now. Under the ONDC, what will happen? Let's say you are going on to the Amazon and you type this particular Nike shoes. Now on the Amazon, even the seller from Flipkart will come. Here, even the seller from, let's say, the Meesho, or seller from some another startups, all of them will feature on the Amazon. Even if you go on the Flipkart, Amazon seller will feature, some other website seller will feature, this particular thing will be there. So basically you will go on to one platform, and on only one platform you can see all the sellers across all the platforms. That is the ONDC. So government recently, what had happened, the DPIIT, that is the Department for Promotion of Industry and Internal Trade, DPIIT, it has basically tested this particular thing on the pilot basis also, and it has been provided that over the years this ONDC will be rolled out for the entire country. Fine. Now guys, it has been said that when the ONDC network will come, all the products and the services, they will participate on e-commerce platform. Fine, all the network apps, you can access that particular thing. It will enhance India's e-commerce industry. India's e-commerce industry will reach to $200 billion by 2027. This is something that will happen. But guys, when our e-commerce industry will increase in size, there will also be the disputes that will be coming. Suppose you bought some product and you got a faulty product. Now your grievance is not being heard by the site or such kind of a thing. So there will be also the disputes. So how to deal with this particular dispute? And here it has been said that we cannot just rely on to the consumer courts, we cannot just rely on to the consumer forums and all these kind of things. It has been said that now what we should do, we need to explore the idea of the online dispute resolution. Now this online dispute resolution, it will be quick, affordable, and it will provide the enforceable outcomes. Is it clear or not? So it has been provided. Moreover, this online dispute resolution needs to be made a 24/7 facility, so that every person from the remotest of the remotest corner can approach this online dispute resolution. Here an example has also been given. For example, the National Payment Corporation of India is there, NPCI. Now NPCI is one who had come out with the UPI, Bheem and all these initiatives. So NPI has mandated that on their UPI platforms, all the applications which are using the UPI platform, they have adopted the ODR, online dispute resolution mechanism. So if you have, let's say, transferred the money from the Bheem app and the money actually got deducted from your account, but it did not got transferred to another account that you wanted. So for that, there is an online dispute resolution mechanism where you can raise the complaints. They will be given a grievance. So on this particular line, on every particular platform, we need to come out with this ODR mechanism, which will help, and actually it will reduce the burden onto the consumer courts and on another avenues. Fine. So this is something that has been provided. Now guys, it has been said that by this, the consumers will also be provided another choice. Okay, and this particular thing will help. So basically we have taken a target that over next 5 years we need to add $48 billion into the gross merchandise value. So this needs to be the merchandise value that is being bought from these sites. So in order to do that particular thing, you need to also enhance the confidence of the buyers. And how the confidence of the buyers can be enhanced? Only when they have an effective remedy for the dispute, and in that capacity online dispute resolution is going to be an important thing. So that's all which has been provided in this particular article. Now we'll move to the next article. Lessons for India from the Taiwan standoff. So this particular article will see with respect to GS paper number 2, international relations. Okay. Now guys, what has happened, basically, first of all, if you are following the newspaper analysis regularly, you know this particular thing a lot in the detail, because from past 4 days, every day we are discussing this similar article. So what has happened, basically, US House Speaker Nancy Pelosi, she visited Taiwan. Now, when we talk about the Taiwan is believed by the China that the Taiwan is not an independent country. Rather, Taiwan, it is a part of a mainland China only. And therefore, China says that no country should maintain the independent relation with the Taiwan. No country should maintain independent relation with the Taiwan. They should not hold the diplomatic engagements with the Taiwan if they want to engaged with China. So they have to decide either it is China or it is Taiwan. Now, in this particular capacity, the USA's representative Nancy Pelosi has visited Taiwan and it has upsetted the China. China says that this is wrong, and now the China is carrying the military interventions around the Taiwan Strait and all those particular regions. So China is showing a confrontation in this particular episode. By the way, guys, yesterday and the day before yesterday, I have discussed this particular issue in much more detail. We have up till now, just for your revision, we have discussed the strategic ambiguities concept. We have discussed the concept of the strategic ambiguity of USA. We have discussed the concept of the strategic clarity of the USA. Fine. We have seen then the concept of the studied silence of India. We have seen the concept of the studied silence of India, that is the India's response in this particular Taiwan, and yesterday we have discussed this particular article. Okay, so guys, from the past 2 days we are seeing it. Okay, and this is a summary that I had given you. Moreover, guys, if you have missed it, please go and see these particular issues. You will find it into the timestamp. Now, coming to the present article. So basically the article says that we can learn something from the Taiwan in this particular standoff. Here it has been said that, see, when the Nancy Pelosi has visited the China is very much irritated. Why? Because China today is claiming to be a superpower. But if China cannot have a control over their neighbors, China have taken it as a kind of a insult on their ego. What actually has happened? China claims to be a superpower, and in that capacity, the Taiwan, which China claims to be their own part, that Taiwan is maintaining an independent foreign policy with the rival of China, that is USA. So China is irritated on this particular thing. Now, guys, what India can learn? India can learn that actually the Taiwan, its population is just 23 million people, and Taiwan has decided to stand against one of the strongest military and strongest economic power on the earth, that is the China. So basically, today the India is much more bigger when compared with the Taiwan. India's army's size is 1.4 million, which is such a big thing. Fine. So therefore, why India is hesitant while China is doing such kind of behavior in the Galwan Valley around the LAC? So the article says that we need to learn a lesson from the Taiwan and we need to stand against the China more clearly. Now the article says this particular thing that basically what we can learn from the Taiwan is that we need to articulate clear red lines. We need to clearly provide our sovereign positions. For example, the Jammu and Kashmir, it is a part of the sovereign India, and in no way the Jammu and Kashmir's territory can be compromised. Even an inch of territory cannot be compromised. And when the China is illegally coming around the LOC, it is taking up the India's territory, then India needs to give a very clearly worded warning to the China, as has been done by the Taiwan. So article is saying this particular thing. Now it has been said that in international community we need to provide very clearly that how China is carrying the incursion into the LAC as the Taiwan has done. Moreover, guys, it has been said that basically Taiwan, now the China is saying that they are carrying the blockade. China is sending its aircrafts into the air defense zone of the Taiwan. Taiwan could have avoided this particular thing very easily if they would have said that Nancy Pelosi should not come in the Taiwan, but they did not do that particular thing. Fine, they know that there will be a retaliation but the China, but still they have decided that they will stand against the China. Now the Taiwan, it could have gone for the appeasement of China. Now appeasement of China is a very safe kind of a strategy. Taiwan could have taken that, but no, they have not done that thing. So India needs to learn. Now guys, here it has been said that many times India don't stand against the China, and the argument that is being given is the economic and trading relationship that is existing between the India and China. But actually India should not fear this particular thing, or India should not be apprehensive actually about this particular thing that there is a big economic relation, because in that particular capacity it is a two-way process. Moreover, there is a trade deficit in China's favor. We import more from the China, so there is a trade deficit with the China, and in that capacity actually China should be more concerned that if India will be angry, India will be frustrated, and if India will not carry the economic relation, then China will bear a lot of losses. Today, guys, when we talk about the China and Taiwan, there also a big economic relation between them. So China is Taiwan's largest trading partner, and China has an annual trade deficit of around $80 billion to $130 billion with the Taiwan. But still, Taiwan stood against this particular thing. So therefore, something could be learned from the Taiwan. This is the entire message that has been given in this particular article. So guys, I hope that you have understood this article, and with this, now we'll go to the next article. So the next article, Center launches a portal to register for rations. Now guys, before going in this particular article, little bit of a background I'll tell you. Meanwhile, this article is going to be important in GS paper number 2, nutritional security, food security. Clear? Moreover, in GS paper number 3, public distribution sector, public distribution system, PDS and PDS related issues, reforms, also this article is important. Now, basically guys, when we talk about the right to food has been guaranteed as per the National Food Security Act 2013. So National Food Security Act 2013 has guaranteed the right to food. Under this particular act, it has been provided that 75% people into the rural areas, 50% people into the urban areas, and on the pan India, 66% on an average in the entire country in the entire country, 66% people will be provided highly subsidized food grains. 3 rupees kg rice, 2 rupees kg wheat, and 1 rupees kg coarse grains will be provided to the people. 66% people will get the food. Now guys, if you want to get the food under the National Food Security Act at these subsidized prices, you need to have a ration card. Now guys, actually in order to get the ration and all these ration cards and such kind of a thing, Center had come out with the online portal. So what is this portal? So the portal's name is Ration Mitra. Now this Ration Mitra, it is a software which is developed by the National Informatics Center, NIC, and it will be used to enroll people of any state. All the states people can enroll that. Now what this facility will allow? Facility will enable the states to identify and verify the eligible beneficiaries for the coverage under the National Food Security Act. So for the verification of the, now I told you that under the National Food Security Act you need to have a ration card. So therefore, for the ration entitlements and their verification of the beneficiaries, this Ration Mitra is going to help the states, and all the states will be eligible on this particular thing. So this is all about this particular article, guys. Just now see on this thing, our full-fledged article, a full-fledged question in the mains examination will not come. Ration Mitra, just you can use that how government is using the e-governance platforms to verify the beneficiaries of the food ration. Fine, in a e-governance you can use it as an example. Moreover guys, basically even in the prelims examination such kind of a thing could be asked, but in the prelims very broad questions are there, but as the name suggests, the Ration Mitra, so even the moment the option will come, you will be able to know that it has to something to do with the verification and all such kind of things. So this is all about it. So you can use it just as an example, as a reference. Full-fledged question is not expected too much, to be very frank on this thing. So that is all about this article, guys, and with this we come to an end to the today's analysis. Now guys, we will be meeting on Monday. Okay, so every Saturday I give you a message that please first of all follow the Monday to Saturday newspaper very diligently, and please keep Sunday as a day for revision. Don't be driven by the FOMO, that is the fear of missing out. Sunday we don't take analysis because there are certain reason. Reason number 1, on Sunday there is no editorial. Reason number 2, on Sunday the text and the context section doesn't comes. Third, on Sunday the leisure, lifestyle and all these particular kind of pages come which are not relevant for UPSC examination. On Sunday there is one page on FAQ which is there, but it contains majorly the summary of the articles that we have already covered into the entire week. Okay, so guys, Sunday I will suggest that please keep it a day for your revision and consolidation, because if you are not able to if you are not revising, you cannot be reproducing the content in the examination, and if you are not able to reproduce the content into the examination, it doesn't make a difference even if you have read it or not. So that is all about, guys, and now we'll be meeting on Monday. Till then, please take care of yourselves, and thank you so much. And if you have liked the video, please do hit the like button, please do subscribe, and please do leave your lovely comments. Your likes and your comments are a very important part, as it gives us a constant energy to work even more hardly. Thank you everyone. Take care.